You may be wondering why a channel that is devoted to trial analysis is going to be discussing today a case from 1803, Marbury versus Madison. And maybe it's a case that you've heard about before, but you probably haven't heard about the part that we're going to be discussing today. And the reason for that is that most of the attention of this case is given on the end of the opinion. It's a long opinion, and if you read the entire opinion in law school, it's a complicated opinion, and therefore the last part of the opinion is usually the easier part to concentrate on, and it's the most juicy, because after all, the last part of the opinion is where he shatters all of Marbury's dreams. And he says, I'm sorry, I just don't have the power to do what you're asking for. And he also, in that part, establishes judicial review. And this is what you hear about. This is the first case in con law, judicial review. And that's an important part. And also, if you have a really good professor, maybe you have a really good professor or you're a really good law school, then maybe he'll even talk about, or she'll even talk about, the political question doctrine. Now, those things we're not going to get into today, because if you're familiar with Marbury versus Madison, this is the big talking points: the political question doctrine and the establishment of judicial review. But what everybody really glosses over is the first part of the opinion. And the reason for that is because it's a little complicated and it really is not so important. But I think it's very important, because there's two parts to reading opinions. One part is to understand legal doctrine, to understand what the case is, what are the holdings of the cases. But another part of why you read opinions and why we go through this analysis on this trial is to help us get smarter, to help us teach each other how to think. Let's learn how to think. And the way that we learn how to think is by going through the analysis that some of these judges went through in their opinions. And I think that the analysis that Justice John Marshall provided in the first part of this opinion, I think is very important. And you can really spend a lot of time thinking exactly what these words mean. So we're going to take a stab at it today. And of course, I welcome all comments. You can tell me what your opinion is about some of these, some of the pieces that we're going to discuss today. But I'm going to give you what my view of his opinion is. Now, the reason why this opinion is important, even in today's day and age, is because the circumstances that led to this opinion is what seems to be unfolding in front of our eyes in 2024. And what do I mean by that? In 1800, John Adams was beaten in the election by Thomas Jefferson. Now, to understand what was going on then, you just have to understand a little bit of the context there. There were two parties. There was the Federalist Party and there was the Democratic Republican Party. And they couldn't stand each other. Very similar to what we see today. And the Federalist Party just lost. John Adams lost. And there was going to be a transfer of power to Thomas Jefferson. And Thomas Jefferson was a Democratic Republican who the Federalists hated. And he was going to start putting all of his people into power. And therefore, at the last hour, which is why they're called the Midnight Judges, John Adams started stacking the courts with judges that were Federalists. And this way they can retain some sort of control and, in their view, save the country. Because in their mind, if the Democratic Republicans were going to take over, then that was going to spell the end of the country. Ever hear this rhetoric now in 2024? Well, that was going on in 1800. This was the exact circumstances that were going on. And John Adams, therefore, literally the day before he left office, he nominated, and they went through the Senate hearing process, and they were confirmed, and they eventually, a number of judges were appointed. But what happened is that he left office, and there was still a stack of those commissions that were not sent out to the judges. So the judges are there at home waiting for their letters saying that congratulations, you got the job, and they didn't get them. And then Thomas Jefferson walks into the office the next day, first day as president, and he sees these stack of letters that are supposed to go out to these future judges who are all confirmed. And he says, you know what? I'm not going to send these letters out. I'm not interested in these judges, these Federalist judges, having all this control. I'm just not going to send them out. So therefore, they're not going to ever get their commissions. Sorry. Well, one of those judges was a fellow by the name of William Marbury. And William Marbury is sitting at his home waiting for this letter, and it's not coming. And he realizes what happened, that Thomas Jefferson is not going to send him his letter. So he goes and he files what we call an original action with the United States Supreme Court. And normally the United States Supreme Court is a court that reviews lower courts. Here, he jumped the line and he said, you know what, I'm just going to go straight to the United States Supreme Court. And he asked for a writ of mandamus. What's a writ of mandamus? Well, a writ of mandamus is, as we discussed before, this channel, basically just the United States Supreme Court telling another court or body or person to do something. That's basically what it is. They're saying, you got to do this. Go do it. And essentially what he was asking the United States Supreme Court, this is Marbury, what Marbury was asking is to order Thomas Jefferson, or in this case, James Madison, he's the Secretary of State for Thomas Jefferson, to send out his letter. And now he's going to be the judge. So that's what he was asking the United States Supreme Court to do. Force Thomas Jefferson to do it. Now, here's where it gets even more interesting. John Marshall, Chief Justice John Marshall, was a Federalist, right? So he was on John Adams' party. He was on their team. Thomas Jefferson was on the other team. And he heard, Chief Justice John Marshall, he heard, through the grapevine, I guess, that even if he orders Thomas Jefferson to send out those letters, or James Madison, they're not going to do it. They're not going to listen to him. Can you imagine such a thing? That's crazy. The president's not going to listen to the United States Supreme Court ordering him to do something? So he realized that if I send him that order, the court's going to look very weak because he's not going to listen. On the other hand, if he doesn't rule in the Federalists' favor, well, he's going to fall out of favor with his party. His party is the Federalist Party. So he is really stuck in a jam. What is this Chief Justice supposed to do? And you can really sense it from his opinion. And this is what he says in the beginning of his opinion. And you can really read between the lines here. He says, the peculiar delicacy of this case, the novelty of some of its circumstances, and the real difficulty attending the points which occur in it, require a complete exposition of the principles on which the opinion to be given by the court is founded. Oh boy, you can really read between the lines there. He is really feeling pressure here. This is a very delicate situation for him. So what's he supposed to do? And this is where it gets a little disheartening. Because a judge is not supposed to be caring about political affiliations. As we know, judges are supposed to be neutral. And they're just supposed to be analyzing the law without any biases. And it's very clear that he felt very strongly from the pressure of his own party. So what was he supposed to do? So what he did, and this sets a precedent. This is not what you're going to hear in law school. It's not going to hear in any of your AP government classes. What he did was he set a precedent for judges and justices to punt. Instead of actually ruling with what he believed the law to be, he figured out a way to make both people happy and then dress it up in a legal fashion. And that's what he did. What he did in this case is he said, I'd love nothing more than to order Thomas Jefferson to send those letters out. I would love it. And that's probably what he told his Federalist friends. But the problem is that the United States Supreme Court just doesn't have the power to do that. I would love to do it, but we just don't have jurisdiction. Because he found that this statute that allows the United States Supreme Court to issue a writ of mandamus in this situation, he found that statute to be unconstitutional. And therefore he said, I'm sorry, folks. This is not what he said in the opinion, but this is essentially what he said. I'm sorry, guys. I would love nothing more to force him to do it, but I just don't have the power to do it. And therefore, Marbury was really stuck. Because Thomas Jefferson never sent him out his commissions. James Madison never sent him out his commissions. And that was the end of that. But what this precedent, it showed that from already 1800, judges were making determinations not just based on the law. There was political influences that were making their decisions. And to give you a little bit of better understanding of how this works, I'm going to tell you a little parable. The parable goes the following. There was a boy walking through the forest, and he sees on the different trees in the forest, he sees an arrow, and the arrow, there's a target on the trees, and the arrow is right in the middle of the bullseye. And in every single tree with a target and an arrow, the arrow is right in the middle of the bullseye. And he can't believe it. How can there be someone who is so amazing, so perfect, that every single arrow he shoots, he gets the bullseye? He couldn't believe it. And he's looking around for who's shooting these bow and arrows, these arrows. And he finds someone. And he sees that this is the person. And he runs over to the person and he says, tell me, how many years of training did it take you that every single time you're able to get a bullseye with the arrow? And the man laughs and he answers him and he says, let me show you. Let me show you, son, how this is done. And he takes out an arrow, takes out his bow and arrow. He shoots an arrow right into a tree. And then he goes over to the tree and he paints a target and he paints a bullseye right where the arrow went. So that's how I do it. And unfortunately, sometimes that's how judges make opinions. That's how they make their findings. They have their arrow, they know exactly what they want to do, and then they just paint around it and use some statutes and some case law to back up what they really were always going to do. And this case is the first case where we see an example of that. And unfortunately, we see situations like that as well. This is not what you're going to hear in law school. So that's why you tune into my channel. All right. So now let's jump into the first part of this opinion, because aside from knowing legal doctrine, it's not the only reason why you go to law school and why we analyze these cases together. Part of the reason is so that we can open up our minds and be able to learn how to think. And these exercises help us learn how to think. And that way, when it comes to analyzing cases, we can be a little more objective and we can be a little bit better, take a better look at it and better analysis on these cases. And that's why it's important. So even though most of the time you're not going to hear any analysis on the first part of this opinion, that's what we do in this channel. So here we go. The first question that Chief Justice John Marshall had was the following. Has the applicant a right to the commission he demands? Marbury wanted the commission. He wanted that piece of paper. Does he have a right to that commission? So here we go. And remember, he did break down this opinion into 3 different questions. The last one's a little more famous, so we're not going to talk about that so much. The second one's also a little more famous. The first one, people just gloss over. So let's do a more of a deep dive into the first one. The second section of the second article of the Constitution says the following. The president shall nominate and, by and with the advice of consent of the Senate, shall appoint ambassadors, other public ministers and consuls, and all other officers of the United States. The third section declares, so this is the third section of the second article of the Constitution, that he shall commission all the officers of the United States. So, Chief Justice John Marshall says, see very clearly that the president has 3 jobs here. Number 1, nomination. Number 2, appointment. And number 3, commission. And we have to understand the difference between appointment and commission. What is the difference? So this is where Chief Justice John Marshall tries to explain. The acts of appointing to office and commissioning the person appointed can scarcely be considered as one and the same, which means they cannot be considered one and the same. They are obviously different, since the power to perform them is given in 2 separate and distinct sections of the Constitution, right? The Constitution will not tell the president that he has two things to do when it's really just one thing. The distinction between the appointment and the commission will be rendered more apparent by adverting to that provision in the second section of the second article of the Constitution, which authorizes Congress to vest by law the appointment of such inferior offices as they think proper in the president alone, in the courts of law, or in the heads of the departments. So, essentially, what he's about to explain, I'm not going to read it, but what he's about to explain is that there are situations where the president himself does not appoint someone to do something, but he still has to commission them to do it. So that's how the point just comes out, that you see that appointment is different than commission. Now, he turns to this case. And this is what he says about this case, understanding that commission is different than appointment. This is an appointment made by the president, by and with the advice and consent of the Senate, and is evidenced by no act but the commission itself. So if there would be some way to evidence this appointment other than this commission, which we'll refer to as this piece of paper that says commission, so if there's no other act, then the only thing that evidences the appointment is the commission, right? So now, in such a case, therefore, the commission and the appointment seem inseparable, it being almost impossible to show an appointment otherwise than by proving the existence of a commission. So here's the problem here. Where is the commission? Marbury doesn't have the commission. So where's the commission? The commission is the only evidence that there was an appointment. Still, says Chief Justice John Marshall, the commission is not necessarily the appointment. So the commission is not the appointment. The appointment happened already. The commission, he says, is conclusive evidence that an appointment happened. So understand the distinction. It's not that the commission is the appointment. It's that the appointment was done already, and the commission is simply evidence that an appointment was made. But, here's his next question. But at what stage does it amount to this conclusive evidence? So again, his point is that we have no other evidence. We don't have any other acts. The only thing that we have right now is the commission itself. Now the commission is conclusive evidence that an appointment was made. But at what stage? At what stage does it amount to conclusive evidence? This is what he says. The answer to this question seems an obvious one. The appointment, being the sole act of the president, must be completely evidenced, here we go, when it is shown that he has done everything to be performed by him. If the president shows that he did everything that was required of him, he signed every paper, filled out every form, made every phone call, whatever he needed to do, if all of his actions were done, that is when the commission becomes conclusive evidence that an appointment was made. The last act to be done by the president is the signature of the commission. He has then acted on the advice and consent of the Senate to his own nomination. The time for deliberation has then passed. He has decided. His judgment on the advice and consent of the Senate concurring with his nomination has been made, and the officer is appointed. This appointment is evidenced by an open, unequivocal act, and being the last act required from the person making it. So, that's it. As long as the president did everything he was supposed to do, then now the commission becomes evidence of the appointment. So, now the question is, well, maybe the commission has to be sent to the justice. It's not enough that a commission was made. that a commission exists in the ethera. It has to be that the commission actually was sent to the judge. And he considers this question. So here it goes. In considering this question, it has been conjectured that the commission may have been assimilated to a deed, to the validity of which delivery is essential. So maybe, hold on a minute, maybe a commission is more like a deed, and a deed is only valid upon delivery. So, this is what he feels about that. The appointment being under the Constitution to be made by the President personally, the delivery of the deed of appointment, if necessary, to its completion, must be made by the President also. So he says, hold on a minute. If you're right, let's just play this game for a second. This is what he's saying essentially. Let's just play this game. That's what he says first. So that means that who has to do this? The President, right? The Constitution said very clearly the President has to nominate, appoint, and commission. Well, the President has to do this, right? Okay. It is not necessary that delivery should be made personally to the grantee of the office. It is never so made. The law would seem to contemplate that it should be made to the Secretary of State. After all, the Constitution says that after the President signs it, gives it to the Secretary of State, and the Secretary of State really is the one who affixes the seal and records it. If then the act of delivery be necessary to give validity to the commission, it has been delivered when executed and given to the Secretary. So if that is really necessary, well, that already happened because the President gave it to the Secretary of State for the purposes of being sealed, recorded, and transmitted to the party. So since it has to be done by the President, and the Constitution says that the President gives it to the Secretary, well, then that's done. As soon as the President gives it to the Secretary, game over. Commission's done. So even if we play that game, still, it was done. The transmission of the commission is a practice directed by convenience, but not by the law. It cannot therefore be necessary to constitute the appointment which must precede it and which is the mere act of the President. So to think about this in a little bit of a different way is imagine somebody goes through law school. They go through the entire law school. They do everything that they're needed to do. They graduate, got all the credits, everything that they needed to do. And now they just don't get the paper. They don't get the diploma sent home to them. Does that mean that they didn't graduate? Does that mean that they don't have a degree? No, they just didn't get the paper. So essentially, that's similar to what's going on here. Chief Justice Marshall is saying that to answer this question, has the applicant a right to the commission he demands? The answer is going to be yes, because as long as the President did everything that he was required to do, so that will then make the commission final, and then it will be evidence of the appointment. Oh, but where's the commission? I don't see it. Where's the paper? It doesn't matter. It doesn't matter because the President did everything that he was supposed to do. He gave it to the Secretary, and that's it. And that's how he answers the first question. All right. Well, that will be it for today on the Marbury versus Madison case. If you feel that this was a nice exercise, and maybe you'd like to hear some more about some of the more important cases that have been going on throughout history, let me know in the comments. If not, we'll just stick to trial analysis, and that'll be it. All right. That'll be it for today. See ya next time.